historically and traditionally, a reviewing court, an appellate court, is asked to conduct a harm analysis or a prejudice analysis in response to an IAC claim. There's some degree of speculation in which the reviewing court has to necessarily engage. You have to necessarily look at the post-conviction evidence, the motion for new trial evidence, if it's a motion for new trial, or the evidence supporting a writ, if it's a writ under 1107. You have to look at the post-conviction evidence and then tack back and speculate, well, what would the trier of fact possibly have done differently had they had this newly developed evidence? We don't have to engage in that speculation here. That's what sets this case apart. To not to put too fine a point on it, Chief Justice Gray, but in order to be entitled to relief, Holden Crusette has to prove by a preponderance of the evidence that John Brick, who's right there, the trial judge, John Brick, abused his discretion by finding that after he heard all of Holden Crusette's post-conviction motion for new trial evidence, his confidence in his own sentencing decision was not undermined. That's what he has to prove by preponderance of the evidence, that John Brick abused his discretion by not ruling that his own confidence in his own verdict on punishment was undermined. And on the record that's before us, there's no way that this court can do that. And I think this is a perfect illustration of why the law is so clear that it is not the role of this or any other reviewing court to substitute its own judgment for the judgment of a trial court, because John Brick was the one who was there. He was there at the trial level, hearing all the punishment evidence from both sides, which, being frank with you, the punishment evidence in terms of substance presented at the motion for new trial hearing was not that different than the punishment evidence in terms of substance presented at the trial level. And we can talk about that in a minute. But nevertheless, Judge Brick heard all of the trial evidence, aggravating and mitigating, made a decision toward the bottom end of the punishment range, 8 out of 20, and then at the motion for new trial level, heard all of Dr. Fabian's testimony, Mr. Thibodeau's affidavit, Dr. Fabian's affidavit, Fernando Crusette's testimony and affidavit. All of that was heard, viewed, and considered by Judge Brick, who then found that his own confidence in his 8-year sentence was not undermined, and that is literally the prejudice standard under Strickland.
But isn't it true, counsel, that when he was listening to that, and you talk about, you cite Hutchins a lot.
I do.
Will you agree that Hutchins is a little bit different here? Because in here, apparently, if we believe the briefs, there was a lot more detailed evidence available in those medical records, which were not admitted because counsel didn't do it right. And that you in your own brief say there was the substance of Alan's medical records and evidence were testified to by the father.
Correct.
But not necessarily detailed evidence. Does that make any difference?
No, and I will explain why. First, as to your question about the content of the medical records that counsel did not obtain or seek to obtain in admissible form, we can't sit here now and speculate on what's in those medical records because they're not in the record still today. Some of his records are, and there's basically 3 sets of medical records. There's his hospitalization records from Houston, Ben Taub, and the other hospital. And then the 3rd set are the records from his treating physician, Dr. Jack Alford. Those are in the records, and those are the ones that trial counsel Mary Kahn had. And going back to the point that you made during Mr. Thibodeau's comments, Justice Johnson, Mary Kahn, and testified about this in the motion for new trial hearing, made a strategic decision not to put those records in precisely because, yes, they contain some mitigating information, But that's the mitigating information that she had Fernando Cruzet testify to, the nature of the injuries, how those injuries have affected his son. But those records also contain quite a bit of aggravating information, that he continued to not follow his doctor's instructions, that he continued repeatedly to use and abuse alcohol and drugs, even after his physician told him not to, over and over again. His inability to listen to and follow directions or make the kinds of decisions that he wanted, that the doctors wanted him to make. And that evidence was aggravating, and Mary Kahn testified at the motion for new trial hearing that she made a conscious and deliberate and strategic choice not to introduce those for that reason. As to the contents of the other records, we can't speculate that because they're not in the record, and so we can't go there. You talked about Hudgens, and I want to address that because your question kind of goes to a similar point that Mr. Thibodeau made in his reply brief with respect to Hudgens. And I, again, respectfully disagree with it because Mr. Thibodeau's argument with respect to Hudgens and why Hudgens should not bar him from relief in this case is that he said it in the brief and he said it again here today. Here, there is no question. This is his argument. There's no question that Holden Cruzet suffered a traumatic brain injury. And that's kind of his go-to response to Hudgens. Well, I agree with that. There is no question that Holden Cruzet suffered a traumatic brain injury, just as in Hudgens, there was no question, there was no factual dispute that Hudgens was sexually abused as a child. That's not the underlying.
Well, the point of Hudgens is that there's no question that he was sexually abused. The question was whether or not there was post-traumatic stress disorder.
That's exactly correct, Your Honor. And here, the question is not, did Holden Cruzet suffer a traumatic brain injury? The question, as appellant has framed it in the brief and in his argument, is what were the effects of that underlying brain injury on Holden Cruzet? And that's what Hudgens goes to. Even though we know Hudgens was sexually abused as a child, and this expert said, yeah, that can cause all kinds of bad things, including PTSD, there's no evidence in the record supporting or supporting a finding that the trial court abused his discretion by not reversing the case on that basis. Apply that to here. Yes, we gladly stipulate that Holden Cruzet suffered a traumatic brain injury, but there's no evidence in the record on this record as it exists about how that injury affected him and how that injury contributed or did not contribute to the fact that he walked into a woman's home and pointed a gun at her in the middle of the night. We have testimony from Dr. Fabian that there's a whole laundry list of things that a traumatic brain injury can do to someone, and that's exactly how he couched it in terms of his testimony. In fact, I cite to it in the brief, Dr. Fabian's testimony in response to a litany of questions from Mr. Thibodeau about TBI. Can it cause this? Can it cause impulse control problems? Can it cause, all this laundry list of things? And the place where Dr. Fabian gets is, yep, all that's possible. But he never says that's what happened here. And interestingly, the only evidence in the record that sort of speaks directly to that as it applies to Holden Cruzet specifically is testimony that's in the record from Mary Kahn at the motion for new trial hearing, where she said, and as your honors know, Mary Kahn had initially intended to call the the appellant's treating neurologist, Dr. Jack Alpert, to testify during the punishment hearing. But then when she talked to Dr. Alpert, and this is in the record, he told her that in his opinion, as appellant's treating neurologist, that injury is not what caused him to walk into that woman's home and point a weapon at her. And as Mary Kahn, I think, aptly put it in her testimony and in her affidavit, the appellant's treating physician's testimony would have, her words, killed him at trial, because he said, no, this is about his continued drinking and drug use. It's not about his injury.
And you making that argument makes me ask this question as framed by the brief from the appellant. Why would trial counsel have allowed the prosecuting attorney listen in or participate in the conference call without knowing that ahead of time?
Yeah, that was stupid. That was stupid. There's not another word for it. That was stupid and that was an error. But as all of you well know, the Strickland standard is not you're entitled to errorless counsel. It's you're entitled to effective assistance of counsel, which also can half of the ineffective assistance analysis deals with prejudice. And with respect to Mary Kahn's stupid decision to have that conversation with Dr. Alpert in the presence of the prosecutor ended up not being prejudicial because Dr. Alpert didn't testify. Mary Kahn was able to get in, as Chief Justice Gray, you pointed out, all that medical information in front of Judge Brick anyway, without Dr. Alpert's commentary on it. That was an error, but it was not a prejudicial error. And I see my time has expired.
I would like for you to briefly address, opposing counsel didn't make mention of it, so I don't think it's foreclosed. The issue 2 and 3 specifically, and the United States Supreme Court's sort of criticism of Texas practice of treating this problem of ineffective assistance of counsel on a writ, post-conviction writ.
Criticism of
Of
motion for new trial or?
No, of the, by using 1107 writ without counsel, and how that, whether or not, how that plays into what we're doing here.
Sure. Directly to answer your question, I don't think it plays into what we're doing here. There is no authority that exists, and Mr. Thibodeau has not cited any because there's not any, that supports his argument that Rule 21.4's time deadlines are unconstitutional as applied or otherwise. The commentary from the Supreme Court that Your Honor talks about, yes, they were somewhat critical, but they didn't hold it was unconstitutional. And the Texas legislature, and in this case, the Court of Criminal Appeals, which has the authority, that rule-making authority as it pertains to those deadlines, are within their discretion to set those timeframes, and the law is crystal clear in Texas, and it has been for years and years and years, as all of you well know, that the preferred vehicle for addressing IAC claims is not a motion for new trial, certainly not a direct appeal, and it's not really a motion for new trial. It's an 1107 writ. Doesn't mean you can't do it, and they certainly made, as Chief Justice Gray, you pointed out, a great effort at doing so here. Nevertheless, we're not having this discussion. There was another legal remedy available that would have alleviated the time pressure to get a neuropsych eval done and those kinds of things. But Holden Crusett elected not to avail himself of that avenue. He chose to do it this way. And so it's not unconstitutional. There's no authority that says it's unconstitutional. And within the rules as they exist, this is the record that we have. And this record absolutely does not indicate that Judge Brick abused his discretion in considering all of Holden Crusett's post-conviction evidence and nevertheless finding that his own judgment in sentencing Holden Crusett in the bottom half of a punishment range for a violent crime. And just to finish up, I want to leave Your Honors with this. I cited to Morrow v. State in the brief, and I don't think you could sum this case up any better than the Sixth Court of Appeals did in Morrow when they said, I'm quoting from the opinion, Morrow received a prison sentence on the low end of the sentencing range, and in Morrow, by the way, the sentence was 40 years in prison on a first-degree felony. Morrow received a prison sentence on the low end of the sentencing range for this violent crime. Society as a whole has a strong aversion to anyone breaking into a home and terrorizing the inhabitants, and Texans have a strong attachment to the sanctity of the home. That's exactly what Holden Crusett did. Judge Brick was right to consider that. And in response to Mr. Thibodeau's repeated arguments that Judge Brick should have had evidence to contextualize the traumatic brain injury, that was kind of the theme of Mr. Thibodeau's argument. Judge Brick also rightly considered he contextualized the traumatic brain injury itself, because the evidence is undisputed that that injury was the consequence of Holden Crusette's criminal behavior in the first place. And we know Judge Britt did that because he overtly said so at the moment that he sentenced Holden Crusette to an appropriate 8 years in prison. And for those reasons, Judge, Your Honors, and the reasons that we laid out in the brief, we respectfully ask that Judge Britt's ruling denying Holden Crusette's motion for new trial be denied, because he certainly acted within his discretion. Thank you all for your time.
Thank you.
May it please the court. So I'm going to address the post-conviction issue right up front. So even with this IAC claim, Holden Crusette would not be foreclosed from rewriting an IAC claim on state 1107 collateral writ. The problem is, and this is pointed out in my issues, is that he's not entitled to an attorney on 1107 collateral state writ. He's indigent. I was appointed. We received ACCI funding for purposes of retaining John Fabian. None of that is going to be available on a pro se litigant on collateral 1107 collateral writ who's sitting in a unit someplace. He's going to have to find someone to do the kind of neuropsych evaluation that John Fabian said was necessary. Stephanie Smith estimated that Holden Crusette reads at a 6th grade level. You have a better chance of hitting the Powerball lottery than being able to pull that off on 1107 writ. And because he would not be able to do it on a state collateral 1107 writ by issue preclusion rules, he's poured out on federal writ as well. That is the reason lawyers like me and a whole lot of other appellate practitioners are now pushing back on the idea that you don't raise IAC until collateral writ. If you've got something that is available, and in this case, traumatic brain injury, organic brain damage, then you work 16 hours to try to get what you need to do to get that claim while you have an appointed direct appeal lawyer. And under these circumstances, an IAC claim was properly brought because we had Mary Conn available for all the reasons that have already been made. Let me talk about Jack Alpert for a minute. Now, it's more than stupid. Again, the characterization that my friend Ryan Calvert said, by not talking to this tree, and Albert was treating him for epileptic seizures and grand mal seizures. He wasn't treating him for the neurological deficits. He characterized it as severe, but it's the epilepsy that Jack Albert was treating Holden for. I also have to point out that saying that the traumatic brain injury issues were addressed with Fernando Crusette, those things that I heard the state say, they're all covered in the punishment hearing. No, they were not. A reading of Fernando Crusette's testimony at the punishment hearing reveals he could not speak to, and in fact, he said that the motion for new trial. The first time I heard how organic brain damage caused by TBI affects empathy, impulse control, memory, intellectual functioning was from you. He never heard it from trial counsel. He never heard that from trial counsel, even though trial counsel says, well, I'm aware of what TBI is. And I will say something else. As soon as trial counsel got off the phone with Jack Alpert, after having let the prosecution know that this witness was off the table and in fact, giving the prosecutor additional information to be able to use at the punishment hearing by way of alcohol intake or other things of that nature. She did not go out and seek. She said, I asked the family to go out and get a new treating psychologist. At that point, which was in February of 2021, about 30 to 45 days before the trial of the case was called, she knew that she was bereft of an expert. She had no expert, did not ask for continuance, did not ask for a delay. to go out and get the kind of neuropsychologist or forensic psychologist that you would need in this kind of case. Yes, within the 30 days, if you read page 40 of the motion for new trial hearing, volume 3, in answer to the question, it would have been difficult under the best of circumstances to get that evaluation. What John Fabian says is, oh, absolutely yes. Oh, absolutely yes. And let me very briefly, in the 20 seconds I have left, say this. Yes, Holden Crusette, his TBI, this organic brain damage, happened as a result of a motorcycle accident in which he was evading law enforcement. But he was punished for that conduct. That was the first and only formal charge that he'd ever received. He was punished for that conduct. 2 years deferred adjudication, early terminate, early discharge. It is the effects of the injury that was never developed, either by expert testimony, and because Fernando could not develop because he didn't know, he's a lay witness. Those things that we all know in empathy, diminished capacity, and memory. This case was pervaded by deficient performance, and it harmed Holden, because even now, Judge Brick doesn't have the benefit of this psychological evaluation and will never have, unless this case is reversed and remanded for a new punishment hearing. Thank you for your time.
Thank you, counsel. Thank you. This case is submitted and y'all are excused. Thank you for an excellent argument. Thank you.
Need to restart it. It seemed to be working. Okay, I've shut it down and started.
Oh, have a seat, counsel. We'll give the audience a few minutes to change out. Sometimes we've got new students coming in. And I failed to introduce you. To all the students out there that saw the first introductions and everything, we do have some of our court staff here today. Rick Bradley is with us. When I should have introduced him when I was talking about what we do after this, and that's the only part of the introduction that I'm going to repeat, since there are a lot of new students that have joined us. In the brochures that were handed out that summarize the cases, there are 2 URLs on the page that opposes the Crusette summary that gives you the court website so that you can sign up for to track the case, to know what happens after today. And then another one that shows the YouTube URL so that you can play back the entire oral arguments that we were able to track if the YouTube was working. We seem to have dropped it in our first argument at some point, but I tried to reboot it to see if it'll work. So, Robert, what's it look like out there? Do we have everybody in? Give us just a minute. Okay.
Okay. I might do political. Okay. No. Anything else?
Well, you can't leave yet because Steve has informed me that I mispronounced your name. And so Steve is going to be given the honor of reintroducing you in your capacity with a proper pronunciation.
Yeah, introduced a little bit incorrectly, Dr. Brandon Bronke. The reason I know that is because for 13 years I taught state government at Blinn. And were you ever department head? While I was here? Okay. But I just wanted, names are something that are really personal to people. I happen to have an easy one, Smith. Not many people mispronounce it. I just want to make sure we pronounce Brandon's name right.
Thank you, Brandon. So sorry I flubbed it. It won't be the first time and it won't be the last time, so I apologize. All right, second case on the docket today is City of Madisonville versus Ivan Hernandez, and you're up on your 3 minutes to speak with the audience.
Thank you.
You may proceed when ready.
Good morning, and thank you for having me. It's a privilege to appear before the court, the privilege to do so here in front of you. Before I speak about the case and try to put the argument in a little bit of context that might be helpful to you, let me reiterate or expand upon what Mr. Thibodeau said previously. For those of you who are working in these paraprofessionals in the legal field, getting out and getting practical experience like this puts the work that we mostly do in the office in perspective. So like Mr. Thibodeau, I would certainly encourage you to go to trial, go to court, come to the Court of Appeals. Of course, it's really the benefit that the Court of Appeals brings to all of us. That said, it is my privilege to represent the city of Madisonville. My name is Bill Helfand. I am both the trial counsel and appellate counsel for the city of Madisonville in this case. As you see from the brochure, this lawsuit against the city of Madisonville is filed by a family of the survivors, an individual who was in a plane that crashed while attempting to land at the Madisonville Municipal Airport. As you may know, we have in Texas and in the United States the concept of sovereign or governmental immunity. And that's something we actually brought here from England. That is that, generally speaking, we don't allow the government to be sued, except under limited circumstances. And those are policy considerations that go to protecting those of us, the taxpayers, from claims that might otherwise significantly expose the public fist, the public money. In this particular instance, up until 1970, we couldn't sue the state of Texas or any of its governmental entities like counties, cities, or other special purpose districts for property damage, personal injury, or death caused by negligence. So while there were negligence claims, they weren't redressable against governmental entities. In 1970, the Texas legislature passed the Texas Tort Claims Act. Most states have, and the federal government have a Tort Claims Act, which provides limited circumstances in which one can sue the government for property damage, personal injury, or death allegedly caused by governmental negligence. In this case, the focus is on the question of what's called premises liability, and that is whether a condition of the premises of the airport was defective, known to the city to be defective, left by the city in a defective condition, and thereby caused the aircraft accident that caused the injury and death in this case. What we're going to talk about today is a more narrow issue of that, which is that we have a rule 91A, in our rules of civil procedure that provide for the prompt dismissal of lawsuits in cases where they have no basis in fact or law. And our Texas Supreme Court has said, and this court has also said, that cases have no basis in fact or law when they don't identify a circumstance within that limited waiver. So that's what we're going to address today.
You may proceed when ready.
May it please the court, and good morning, Bill Halpin for the city of Madisonville. If the heavy presumption of immunity about which the Supreme Court continually reminds us, and the burden of the plaintiff to prove a waiver of that heavy presumption have any meaning, Rule 91A effectuates that to the benefit of the public purpose of governmental immunity more than any other pleading rule that we have. And while the appellees argue that this is an attempt to federalize the standard of pleading, that's simply incorrect, because that standard of pleading is already in our own jurisprudence, both from the Supreme Court and this court.
Counsel, there's one issue that we really need to take up first, and that's jurisdiction. 91A, a denial of a 91A motion, which is the procedural vehicle that we chose, is not one of the motions or methods to obtain an interlocutory review. And so, how do we have jurisdiction of an interlocutory appeal of the denial of a 91A?
Well, first, Your Honor, I have to respectfully quarrel with the assertion that 91A is not something for which there is interlocutory review. Under 51.014, and I apologize because this issue was not one that was presented in any of the briefing. I'm going to say 8, Your Honor, subsection 8 allows for an interlocutory appeal of a denial, and I believe that the textual provision says a motion for summary judgment based upon governmental immunity. However, the Texas Supreme Court has repeatedly held that a plea of the jurisdiction based upon governmental immunity may be made by a plea of the made by Rule 91A or by a motion for summary judgment.
So you think the substance of the 91A motion being a plea to the jurisdiction gets you into an interlocutory appeal under that subsection in the Texas Civil Practice and Remedy Code?
If I'm correct, remember that it's subsection 8, Your Honor, which again, I think the text specifically.
Got it. That's the one that says grant or deny the plea to the jurisdiction, but
Right.
that is it's a nuance of whether or not a plea to the jurisdiction is also a 91A motion or if those are two discrete subsets.
Well, again, and I apologize because I didn't know that the court had any concern over that. Let me point out that that's resolved by City of Dallas versus Sanchez, which is cited at footnote 1 on page 8 of my opening brief. The Supreme Court has specifically said a challenge to subject matter jurisdiction based on sovereign or governmental immunity may be raised by any dispositive motion, including under Rule 91A.
Okay,
And
thank you.
that's specifically at pages 7, 24, and 25. If the court would like some further briefing on that, I'm happy to submit.
If you're happy with that case, it is a court by which we are bound. So, thank you.
Thank you, John. That said, as I mentioned, to the extent that Rule 91, to the extent that the heavy presumption of immunity and the burden of the plaintiff to overcome that heavy presumption has any meaning, Rule 91A puts that into effect. And in that regard, the Supreme Court specifically stated that in City of Dallas versus Sanchez, which again is cited in the briefing. In City of Sanchez, and this is a quote, the Supreme Court held a review of a 91A dismissal, and I'm going to paraphrase here, quote, this is a quote, requires a court to determine whether the pleadings allege facts demonstrating jurisdiction. And on this, I think the appellees and I are of like mind. The appellees don't claim that they allege those facts. They simply claim that they're excused from alleging those facts based upon basic notice pleading requirements. But notice pleading requirements take the court in the wrong direction on this case. Because again, in order to state a claim that vests the trial court with subject matter jurisdiction in light of the heavy presumption of immunity, The pleader must allege facts that affirmatively demonstrate the existence of subject matter jurisdiction. That's also in the city of Dallas versus Sanchez case, with a string cite to a number of Texas Supreme Court cases. Now, this court has picked up on that in the Bull versus TDCJ case from this court in 2020, in which the court said, and again, a quote, to determine whether dismissal under 91A is required in this case, we consider whether the pleadings liberally construed allege sufficient facts to invoke a waiver of governmental immunity. The city of Dallas versus Sanchez case from the Supreme Court started with approval the 14th District Court of Appeals opinion in Woolley versus Schaffer, which is also cited in the briefing. Woolley, along with other cases from other appellate courts, but not yet this one, have recognized what is often referred to as the Twombly-Iqbal pleading standard under the federal rules of civil procedure. The court may recall in Twombly and then later in Iqbal, the United States Supreme Court addressed Rule 12b-6, that is a failure to state a claim, by realigning the standard necessary to state a claim in a federal complaint. And what the Supreme Court has repeatedly said, the United States Supreme Court has repeatedly said, is threadbare recitals of the elements of a cause of action are not sufficient to state a claim. The Woolley Court, and again, a couple of other appellate courts which are cited in the brief, have adopted this in addressing the question under Rule 91A as a general proposition. But here, even more specifically, in light of the pleading burden of a plaintiff suing a governmental entity presumed to be immune, the requirement of factual allegations sufficient to identify a waiver of immunity is the threshold question of subject matter jurisdiction. And in fact, that's what this court said in full. In addressing particularly the premises defect case that Mr. Dole raised, the court affirmed the dismissal under Rule 91A from the trial court based upon the fact that Mr. Dole failed to allege all of the requisite elements of a prima facie case sufficient to waive the presumption of governmental immunity. In this case, and based upon a claim under 101.022, as the court knows, the pleading must identify a condition of a premises that created an unreasonable risk of harm to licensee. I'm going to skip number 2 for a moment because it's the coup de grace of the attempt to state a claim here. That the licensee did not actually know of the condition, that the owner failed to exercise ordinary care to protect the licensee, and the owner's failure was the proximate cause of injury. What I skipped was the owner actually knew of the existence of the condition. And again, that was the turning point of this court's affirmance of the Rule 91A dismissal in full. There must be factual allegations which would identify all of those elements. And yet what the court is presented with here, what the trial court had, was simply the same threadbare recital of conclusory allegations without any fact. And in fact, again, this court's opinion in full is instructive because this court went on and explained how allegations would be sufficient to state a prima facie claim and therefore a waiver of the presumption of immunity on each of those elements. And as to the knowledge, this court specifically spoke to the requirement that there be an identification of how and when the owner acquired knowledge of the condition, as well as the fact, as the court will know, as well as the fact that that condition rendered the premises unsafe. Now, again,
So if another plane clipped the same trees and crashed in the same place, then they could plead the prior crash.
well, that's certainly one, but only one of a number of potential examples. This airport is under the supervision of the Texas Department of Transportation Aviation Division that inspects the airport on a regular basis and reports to the city of Madisonville any defective condition. There's also the Federal Aviation Administration, which does the same thing because the city of Madisonville received federal grant money for the operation of the airport. And your honor's question reveals the problem that the appellee has that's not subject to correction now. And that is, one need not rush off to sue the government. There's the same 2-year statute of limitations on a tort claim against the government as there is against a private individual. And I think Your Honor has given one good example, but let me expand upon that and suggest that if a plaintiff wished to establish those elements with fact-based pleading, which this court and the Supreme Court have said are necessary, all they have to do is make a public information act request, because unlike private entities, the city must statutorily respond to a request for information about, for example, whether the vegetation has ever been reported, observed, or identified to be too high and potentially subject to impacting navigation. The fact is, this is the kind of false allegation that's an effort to get into the courthouse door that undermines the very goal of governmental immunity. There is no determination anywhere, including from the National Transportation Safety Board, which inspected the accident, that the vegetation was too high and therefore rendered the airport unsafe. What the report says is that the aircraft impacted vegetation when it landed short of the runway. Well, that should come as no surprise if it lands short of the runway. But if governmental immunity is going to mean something, if the city is supposed to be immune from litigation, not just liability, then the requirement of those fact-based pleadings are essential. And to your point, Chief Justice, they are available if they exist. But in the absence of them, and the heavy presumption of immunity, of which the Supreme Court continues to remind us, the trial court was obligated to dismiss this case. Now, to be sure, in this case,
Now, you said that they wouldn't be able to do that now. Will you elaborate on that?
well, this court should reverse and render a judgment based upon the failure. The trial court could have dismissed the case without prejudice. And this court can reverse and remand the case to the trial court with instructions to determine whether a pleading amendment would be sufficient. So it's certainly a practical possibility, but we arrive at a point at which this court should reverse and render. Because again, those factual allegations aren't there, they were required, and the trial court therefore lacked subject matter jurisdiction. Now, to be sure, this court, and again, Chief Judge, this court specifically said, in determining whether a premises owner has actual knowledge, courts generally consider whether the owner received reports of prior injuries or reports about potential danger. That's from Thole. In the balance of the time that I have left in my opening, I'd also like to point out why this, and this may answer the Chief Justice's question, why this case should be reversed and rendered. Why this case is also subject to the recreational use statute. Because under the recreational use statute, as the court knows, the burden on the plaintiff to effect a waiver of immunity would be to show that the city engaged in some conduct that would be violative of the duty owed only to a trespasser. And there are no factual allegations here, and the facts of the accident itself don't lend themselves to a determination or even an allegation, not within the requirements of Rule 13 of the Rules of Civil Procedure, of a pleading that would allege some actionable gross negligence or intentional conduct on the part of the city. In the Sam Houston State University versus Anderson case in 2008, this court made it clear that its interpretation of the recreational use statute was intended to include, quote, any other activity associated with enjoying the outdoors. And that broad language, that's in the statute, that this court held that broad language evinces an intent to include a myriad of other activities of recreation. There is no factual allegation in this case that the purpose of the flight was anything other than private and recreational. Moreover, in 2015, 7 years later, in the University of Texas at Arlington versus Williams, which is also cited in the brief, the Supreme Court analogized the Texas recreational use statute to the Pennsylvania recreational use statute, said that our statute was more like Pennsylvania. The Pennsylvania statute expressly defines the recreational, non-commercial aircraft operations as a recreational use. And again, as this court has stated, including in the Sam Houston State University versus Anderson case, that like immunity, the recreational use statute should be interpreted broadly to encompass anything that could be determined to be recreational use in the absence of some indication that such an interpretation runs afoul of the legislature's intent to, again, include a myriad of other activities. The last thing I'll point out is that the appellee attempts to circumvent this argument by arguing that the activity did not take place entirely on the city premises. In fact, there's some question as to whether the accident occurred on the city premises at all. But in the city of Plano versus Pomoki case and in the Dubois versus Harris County case, both the Dallas Court of Appeals and the 14th Court of Appeals in Houston pointed out that the recreational use statute contemplates the recreational conduct, not specifically where it happened. It may include journeying to or from the recreational area. But more importantly, the appellate can't have it both ways. They can't argue that there was something defective on the city's property, yet the accident may not have happened on the property itself. The recreational use statute's definition includes all buildings and structures attached to or located on the land. So it would subsume the area of the accident if the appellate continue to stand by the position that the accident happened on the land of the airport itself. So respectfully, the court should reverse and render judgment in favor of the city, finding that the recreational use statute applies, and in the face of no allegations that would fall within the limited circumstances of a waiver of the recreational use statute, amendment would not be appropriate. I appreciate the court's time.
Counsel, before you step away from Mike, am I understanding your argument correctly as far as the court's judgment options? Is that if we do the recreational use statute, it would be a reverse and render, but under 91A, straight up without the recreational use, it could potentially be a reverse and remand.
Your Honor, I concur with the first part of it as the recreational use statute. There are simply no pleadings that if the recreational use statutes apply, would allow any type of an amendment to cure the defect. As to if the court finds that the recreational use statute does not apply, but finds that the plaintiffs have not demonstrated a waiver based upon the factual allegations in their petition, then the court should determine whether an amendment would be sufficient to do so. And I would posit that that's not the case under the facts that have been pled. It would require a very different pleading, and that would seem to alter the case.
Under Rule 91A, can there be pleading amendments at this late date?
There cannot be a pleading amendment under Rule 91A. Thank you, Your Honor. Maybe I misunderstood the question. The question would be whether the trial court would have appropriately dismissed the case without prejudice.
Okay.
Counsel, let me ask one question. You said that the recreational use statute of Texas should be analogous to the one in Pennsylvania. How is it analogous to Pennsylvania actually includes flying, but ours doesn't?
Well, I want to answer by saying I didn't say that. The Texas Supreme Court said that in the University of Texas in Arlington versus Williams case. And if that's the case, then I can't speak to why the Pennsylvania legislature had the foresight to address that issue while the Texas legislature may not, except to say that as this court has observed, and just like other aspects of the Tort Claims Act, the list of recreational activities is not exclusive, it's not exhaustive, it's merely illustrative. And so if we analogize those two, then the illustration from a place with an analogous statute, according to our Supreme Court, then has some meaning. But respectfully, I don't think the court needs to reach that. The court's own explanation of its interpretation of the legislative intent of the recreational use statute, which is to look at it broadly and to expand upon it except to where it's been limited, would reach non-commercial aircraft operations such as the one alleged here without regard to Pennsylvania.
Thank you, John. You'll have 5 minutes on the ball.
Thank you.
You may address the audience with your 3 minutes. Thank you. You may proceed.
I would just like to add Ms. Halpin's summary of our situation here. That it's well known in the legal community anyway, that the Texas Tort Claims Act is a very difficult statute to interpret and a very difficult statute to apply. And I think it's generated as much litigation as any given statute on the statute books. We have another example of that today. And what we have that's what's different about this case is you've heard a lot of references to Rule 91A, and that involves the legislation directed that the Supreme Court create a process whereby a claim that has no basis in law or no basis in fact can be disposed of quickly without spending a lot of money on this particular issue. But by using that particular method, you have to meet their standards, and I think that's the meat of the argument of the appellate. And with that, I think I will address my remarks to court.
Counsel, you may proceed when ready.
Please the court. I have been listening with interest to Mr. Halpin's presentation. And preparing for this argument, and I probably should have picked up on this earlier. I noted that he did not, in his briefing, discuss the facts that were pleaded in, specifically dealing with those facts. And then I realized that the city filed its motion to dismiss under Rule 91A before plaintiff timely amended its pleadings to allege additional facts involving specifically the premises liability claims. And I do quote those, I cite those in the brief that was filed with the court, and I would stand on the facts that it's in the additional statement of facts, statement of the case at the beginning of the brief. I would point out also that the first words that Mr. Halpin spoke to the court and to the audience involved, the heavy presumption in favor of jurisdiction. I would suggest that heavy presumption is generally employed in cases in which discovery has been done, where facts may be considered by the trial court and the reviewing court in determining whether a claim within the waiver of the Tort Claims Act has been stated. Now, this answer, their plea to the jurisdiction using Rule 91A was the first piece of paper that they filed, which obviously is before any kind of discovery was employed in this case. Now, the fact that the statute itself says, number one, no basis in law, number two, no basis in fact, number three, no evidence may be considered in determining this motion. Number four, it allows the pleading party to withdraw its claims if it sees fit, or to amend, which was done here. And in the face of that amendment, then the challenging party has the latitude to withdraw its challenge and remake that challenge, addressing the fresh pleading, and that was not done here. And I would ask the court to direct its attention in further review to the issues that we're not hiding, and I apologize for this. I didn't realize it, but I believe that the facts that were pled are not well addressed by the parties because of this discrepancy.
Are you suggesting that we do not have jurisdiction because they did not file a Rule 91A motion after you last amended your pleadings?
No, I am suggesting that they had the option of standing on the motion that they did file, which is what they did. Now, that motion didn't necessarily address the pleadings that were on file and heard at this hearing. That's, I mean, what I'm saying is they may not have addressed the live issues before the trial court. And I mean, at that point, I would ask the court to remember sorry, if I might have a second here. Again, 91A, like Miranda versus, Texas Parks and Wildlife Department of Miranda. I would refer the court to that case, number one, because it discusses plea to the jurisdiction in detail. And what it states, one of the things that it states is that if the party does not plead itself out of court, in other words, if the face of the pleadings do not reveal an issue, where, for example, they pled an affirmative defense on the face of their own pleadings, but then it's a matter of pleading sufficiency, and there should be a remand to address any kind of deficiency. This was in the context of a motion for summary judgment, challenging jurisdiction, and that's also relevant here because what Miranda shows us is that when you choose a particular dispositive motion to assert your plea to the jurisdiction, then you have to abide by that, the restrictions on that motion, the standard of review, the timing, and then procedure in general. In this case, they chose a case with a heavy burden because it's not supposed to be easy to get these things when there might be merit in the claims asserted. It is not a procedure where you're supposed to be able to foreclose a meritorious claim because there's been no discovery. I would suggest that if we continue down this road with government entities asserting 91A challenges to jurisdiction, then what we're going to have is meritorious claims essentially foreclosed because in this case, he's talked about I'm sorry, I'm blanking on the name of the statute. The Open Records Act. You can always ask for that, except I would suggest that when there's been a death or serious injury, it's really hard to get those kinds of facts out of a government entity, and they have certain entitlement to shield those kinds of records. And records including what they might call personnel actions. And I think as a lawyer with any kind of governmental experience knows that the categories in the Open Records Act, which you can't use to restrict access to records, are malleable and they can be stretched and shaped to cover situations that maybe they shouldn't be covering. And I would suggest that especially would be the case if there was a serious claim of injury or death. And a plaintiff, a potential plaintiff, is required to flesh out this pleading, knowing there's a 91A challenge waiting in the wings. I'm going to suggest that does not meet the requirements of Rule 1, that there's a fair and efficient and speedy determination of causes of action. I think that truly tilts the playing field against the injured plaintiff who has rights to see that the government unit in question is held to account for its actions. In connection with the facts that were pled, I did not hear, as I recall, that there has been all of the talk has been about, well, again, the heavy presumption that supposedly arises in favor of the governmental unit. But 91A has its own standards, and the standards are no basis in law, and that's its definition. No basis in fact, and it has its definition, and they're harsh standards. There is a case which I apologize I don't have in front of them, in which they say what's been said about summary judgment, which is to say, it's a harsh remedy and it's supposed to be strictly construed. And if you are going to, you know, this is a draconian statute. It's supposed to ferret out things like the Bowl case, which Mr. Helfand has relied on extensively. And I believe, I firmly believe that that case was decided on the basis of bisonosis, which the inmate who was the litigant in that particular case claimed that he had this occupational disease called bisonosis, which was a result of the Texas Department of Criminal Justice's faulty safety precautions involving spinning cotton yarn in their factory. Nobody else had bisonosis. There's no medical diagnosis of bisonosis. It wasn't defined, and he could not name anyone else who had to deal with this. I think that's a textbook example of no basis in fact, because no reasonable person could believe that bisonosis was an affliction that, although medical science had not yet diagnosed it and quantified it, and although, you know, this is something that is going to be the basis for a cause of action. That's the definition of fact, of determinative facts, which no reasonable person could believe. And so that is a case that they rely on fairly substantially. And I apologize, I have not done an oral argument in several years now. It's
You're
probably,
doing fine.
it's probably showing at this point. I would simply. Also, this last question, I think it would be a good one to wrap up on, because it is. The city does not really address the issue of whether the behavior described in the petition, namely having an airport that you have that's open for a night landing at a time when, you know, as we allege, as is alleged in the petition, the lighting is inadequate, the trees are too tall. Although we're not supposed to consider facts under a 918 challenge, there are National Transportation Safety Board reports out there that do discuss, you know, that kind of the results, or, you know, a preliminary, the actual report hasn't come out yet, and it probably won't come out for a while. This is my
As to this particular crash,
particular crash, so they know that, number one, that there was contact with the trees on the grounds of the airport, and there was prop damage on the plane, indicating they hit the trees. The props chewed themselves up on the trees. For what that's worth, it's but the question is, if you're opening your airport to a night landing, and you don't, on these shortcomings we've talked about are in fact in existence, would that be grossly negligent on the part of the city of Madisonville? Because there's no doubt that a plane crash is extreme harm. I don't think there's a real factual argument as to, you know, a plane crash, either you're up in the air or you're not, and if you're not, it's pretty extreme. So I mean, I do think that is an issue that might unclarify the situation, because the standard is willful. The city had to refrain from willfully, wantonly, or grossly negligently injuring our plaintiff, or knew of a condition that the plaintiff did not know of, failed to correct it, failed to warn, etc. I don't know if the gross negligence problem of that particular basis of jurisdiction has been adequately addressed.
council, opposing council did address the application of the recreational use statute. You addressed it briefly in your brief, but would you like to address it today?
I would, and before I move on from the liability part, I would ask the court's indulgence in allowing me to review the jurisdictional question which you raised, and which I don't think either one of us actually spied out of the record. I would like to submit a letter brief post submission within 15 days or so, and just to see if there is anything there that might discuss whether there is jurisdiction for a 91A challenge.
We will consider that Friday week letter briefs on the 91A jurisdictional question, but how about the application of recreational use statute?
Your Honor, I truly don't think, I think this is not a strong claim. If you review the cases in my brief, they are University of Texas and Arlington case. But more importantly, and I believe this may have come from this court, it should have, since it was the city of Bellmead versus Torres, in which a softball player came into the park to play softball. For whatever reason, the playing softball is not a recreational activity, which is governed by the recreational use statute. It's important to realize that this statute is kind of counterintuitive that way. But when she was there, she was on a swing set, which broke. The swing set broke, she injured herself. She sued on that basis. And she said, I came onto the park, but I mean, I was sitting on the swing set, and the Supreme Court said, what kind of activity you are engaged in determines whether the recreational use statute applies. And so it wasn't the fact that she came into the park to play softball, which would not have the recreational use statute apply, because competitive sports are not covered by that. However, they determined that playground equipment was in the catch-all, and this is determining the catch-all provision, which they rely on so heavily. That swing set, the fact that it broke and you were hurt while you were using the swing set, that is enough to bring you within the statute, and that means you don't win. I mean, if you read the University of Texas and Arlington case, and I apologize, there are two cases that both deal with spectators at sporting events who are injured. One is a plurality, one is a majority case, and I get them mixed up on occasion. But there is a discussion about that, about why certain activities are covered by the catch-all and why they're not. And it has to do with, if you look at the ones that are covered, it's not an exclusive list, but there are like 15 to 20 activities listed, which are covered. You have to look at those activities and judge in the context of what activities are definitely covered. Is this activity going to be one that you can bring in using the catch-all provision? I believe that the term of art is just generis. And that's the thing. They did use that, and they said, no, spectating is not like these other activities. My client was not flying a plane. He was not engaged in that kind of recreation. He was a passenger, which is kind of like being a spectator, which is kind of like you're not enjoying the outdoor when you're outdoors, when you're in a pressurized metal tube in a cramped seat, maybe on the window seat, but maybe not. That is not associated with enjoying recreation and the outdoors. And I don't think there's any kind of basis for holding their recreational use statute.
Okay, letter brief on the jurisdictional question by Friday week, but you've got 5 minutes on the ball. Thank you, Council.
Sure.
You may proceed when ready.
Thank you, Your Honor. As appellees did in their briefing, counsel, my friend here today, again, is discussing the standard of Rule 91A without the necessary overlay of the presumption of governmental immunity. And let me say that it is incorrect to say that the Supreme Court has ever said that and it is a quote, heavy presumption of governmental immunity only applies at the summary judgment stage. This court has recognized in opposite to that. It is to say that the day before the appellees filed this lawsuit, the city of Madisonville was presumed to be immune from any claim in this lawsuit. The court must presume the immunity. And on the day that the appellees filed this lawsuit, and through the disposition of this case in the trial court up until the interlocutory appeal, the city was still presumed to be immune from suit. So the 91A standard doesn't stand alone and references to private cases without the presumption of immunity, which refocuses the burden on the plaintiff to show subject matter jurisdiction are meaningless because the presumption is there. And that's what this court said in Thole. Counsel discussed facts about Thole, which this court did not and should not have addressed. Because again, the question was not what Mr. Thole could have done in discovery, it's what Mr. Thole didn't do in pleading. The same thing the appellees failed to do here, which was to allege facts, which if true, would make out a claim that falls within the limited waiver of governmental immunity. Now, immunity is the no basis in law. But here, it is not just a no basis in law for purposes of 91A, it's presumed. And again, as this court said in Thole, as the Supreme Court said in the city of Dallas versus Sanchez case, the court looks for facts to show a waiver of immunity based upon those factual pleadings, if true. And in that regard, I appreciate, although I don't think it's to their benefit, the appellees counsel pointing the court to the allegations that are made. They are at record 35, and they are in paragraph 17 and 18 of the amended petition. And counsel is correct to say, as the city was entitled, the city stood on its motion to dismiss under Rule 91A, even after the amended pleading. That is asserted to the trial court that amended pleading also did not effect a waiver of the presumption of immunity, and therefore the trial court lacked jurisdiction. And when the court looks at that, I think it will become blatantly clear how deficient these pleadings are. And I won't go through them, but they are a laundry list of allegedly 8 things the city failed to do. And as it relates to premise defect, they are number 7, and it's number 7. Quote, failing to warn of and eliminate unreasonably dangerous premise conditions. That's it. That's it. And as for notice, this is all the court gets. Quote, defendant had actual subjective awareness of the risk involved in the above described act or omission. That is a purely conclusory, totally devoid of facts statement that simply is an effort to track the law. But that's not what this court looked for under the Thole case, your own authority. I also want to point out that I must respectfully disagree with my friend that information is hard to get under the Public Information Act. As the court should take judicial notice, Your Honor knows, the Public Information Act is designed with the presumption that all information is public except to the extent that the Attorney General or a court determines that it is not public. So information is presumptively available, and in order to avoid making it available, a city or any other governmental entity may not on its own accord refuse to make it available. They must get permission from the Attorney General or a court. Lastly, as for the recreational use statute, there is nothing analogous between being a spectator at a sporting event and being a passenger in a private aircraft that is being used for whatever purpose appellees was using it here in this case. He is a participant in that aviation activity. He is utilizing the city's airport, and the purposes underlying the recreational use statute to protect landowners, including public entities, apply just as much to that as any other recreational use. I see my time is up. Thank you.
Thank you, council. This case is submitted and y'all are excused. At this time, the formal proceedings of today's activities are closed. I'm going to take us off the YouTube feed. And we will go into the opportunity